Here. Here.
Here.
Here.
Here.
Here.
Thank you. It's a big quorum. Pledge of allegiance, please. Everybody stand up. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Good morning, everybody. Give me a brief moment. If you indulge me on I'd like to take a little moment of silence to reflect on what happened the last couple of days with the assassination of Mr. Charlie Kirk. And not to belabor the point, but you know, there's an old Indian tale where an elder man speaks to his young grandchild and says, you have two wolves living inside of you. One is full of anger and rage, and the other one is kind and compassion. And the little boy asks him, which one wins? And the tale goes that he says, the one you feed. In my prior career, I saw a lot of violence more than one lifetime, like other people in this audience have. And it's just sad that, we've come to this. But if you can just, feed the wolf, that doesn't create tension and heartache and hatred. Thank you. Thank you very much. Appreciate it. And first business of the day, I'd like to introduce Commissioner Hellman. This is his first in-live person commission meeting. Welcome aboard.
Thank you.
And then, I'm sorry. Thank you. Let's take a motion for the consideration of July 25th public session minutes.
Move to approve.
Any opposition? Hearing none, the motion passes. Consideration of final action of joint stipulation. Is that item 4? You know what? I apologize. Let me backtrack a second. I'm sorry. My preliminary announcements and my housekeeping rules. The First District Court of Appeals graciously let us use its facilities, so please respect their rules and have absolutely no food or beverage other than water in this room. Please silence your cell phones. We have received some feedback from the public that sometimes it's difficult to hear the members and those before the commission, both in the room and over the live stream. Anyone addressing the commission, please make sure to speak into the long microphone at the podium so you can be heard, so that our broadcast audio and recording equipment can pick up your comments. To my fellow commission members, please speak up into the long microphones on the dais so that your comments and debate can be heard. If you share a microphone with another member, please pull it close to you when you are speaking. Members, I ask that you be as brief and concise as possible in your questions and comments, as we have a number of items for consideration today. Pursuant to Section 286.0114 Florida statutes, members of the public have an opportunity to have input on matters before the commission other than in cases in which we act in a quasi-judicial capacity. This means that the public can have input on matters other than complaints, opinions, and determinations in final disclosure cases. If you desire to be heard on a matter, please fill out the speaker card and give it to Ms. Fulford, who has her hand up in the back. Good morning. All right. And we're off to item 4, correct? Okay. Next, we will consider the joint stipulation in complaint number 22-082, In re Venus Gilmore. Will the parties or their counsels please identify themselves for the record?
Joseph Grant for the respondent.
Thank you, sir. Complainants have the right to respond in writing to proposed stipulations. The complainant's response to this stipulation was included in the mail-out materials. Are there any members in the commission who need to make a disclosure regarding this case? Thank you. Ms. Hadley, you're recognized to present the stipulation.
Thank you. In this case, respondent violated Section 112.3137 by having a conflicting contractual relationship related to his employment with the city of Fort Pierce. Due to this matter, the city demoted respondent from the Assistant Director of Planning position to the position of senior planner and reduced his salary. This commission follows Section 112.317 regarding penalties. Under Section B, in the case of a public employee, the following are options for penalties. 1, dismissal from employment. 2, suspension from employment for not more than 90 days without pay. 3, demotion. 4, reduction in salary. 5, forfeiture of no more than 1/3 salary per month for no more than 12 months. C, a civil penalty not to exceed $10,000, and that's due to the date that this violation occurred. 7, restitution of any pecuniary benefits received because of the violation committed. 8, public censure and reprimand. In the stipulation, respondent admits that he violated Section 112.317 and agrees to the entry of a final order recommending a civil penalty of $1,000 with public censure and reprimand. This is in addition to the demotion and reduction in salary already imposed by his agency, the city, which are also penalties under Section 112.317. That is 4 of the 8 penalties available. We respectfully ask for the Commission's approval of the joint stipulation.
Any questions? Thank you, Ms. Ivey. The respondent or his counsel, any comments?
No comments.
Thank you. Any discussion or debate? Get a motion to approve?
Second.
Any opposition? Hearing none, the motion passes unanimously. Thank you. Okay, the next agenda is going to be item number 5, file number 2817, which was first considered at our last meeting. Any public officer candidate for public office or public employee in Florida who is in doubt about the applicability of the disclosure laws or standards of conduct to himself or herself or anyone who has the power to hire or terminate other public employees may seek an advisory opinion from the commission about himself, herself, or that employee. Advisory opinions are based solely on the facts provided by the requester and are legally binding on the conduct at issue. Are there any members of the commission who need to make a disclosure regarding this matter? The requester is in attendance?
No.
Nope, she is not. Okay, thank you. The floor recognizes, the commission recognizes Steve Zukowski. You may present the opinion. Did I get that right?
Yes.
Okay,
Yes.
thank you. Somehow when I say it, it's easier than when I read it.
I'm amazed every day my wife took my last name. Thank you, Mr. Chair. Commissioners, I'm in the habit of giving credit where credit is due, and most of the hard work on this matter was today before you was done by Stephanie Novanario. She would have stayed on the matter to redraft it and present it to you today, but along the way she had a baby, and we felt it was right to allow her to finish her maternity leave in peace. I want to congratulate her on the birth of her child and welcome her back to the office. So you're stuck with me. The request for an advisory opinion in file number 2817 was brought to us by Flagler County School Board member Lauren Ramirez. She and her attorney could not be here today, but Ms. Ramirez did submit a written response to the new draft, and that has been circulated. If you do not have it, I have paper copies for you. Ms. Ramirez is a school board member who owns a business. She has indicated that she would like to know whether her business can maintain any of 5 separate entanglements with her school district. The draft from the July meeting numbered these a little bit differently, but the draft before you today addresses these as questions 1 through 5. At the July meeting, Ms. Ramirez's attorney indicated that they agree with the conclusion in what is now labeled question number 2, that Ms. Ramirez can volunteer in the schools. They indicated that they agree with the conclusion in what is now question 3, that she cannot market to students in schools while she is in the schools or using school resources. Lastly, they said they agree with the conclusion in what is now question 5, that she cannot obtain placement of her business's logo on the shirts of school teams as part of a bargain for exchange. Because of that, I'm going to spend my time here primarily talking about question 1, which is whether she can sell to students. This question is properly analyzed under the second part of section 112.313, subsection 7A. The second part of the statute prohibits a public officer or a public employee from having employment or a contractual relationship that will either, one, create a continuing or frequently recurring conflict between his or her private interests and the performance of her public duties, or two, that would impede the full and faithful discharge of his or her public duties. The draft gets into this in a little bit more detail, but if the conflict is either frequently recurring or if it would impede the full and faithful discharge of the public officer's responsibilities, even if that impediment occurs in just a single instance, a prohibited conflict can be found. This provision has been around for about 50 years, and the courts have had their opportunities to review it. The fourth DCA reviewed it in 1982 and said, quote, "We do not believe the statute could be more precise and still fulfill its broad purpose." Well, what is that broad purpose that it's fulfilling? It prevents public officers and public employees from entering into contracts or employment arrangements that might tempt them to subvert their public responsibilities in favor of their personal financial interests. When a public officer takes office, they obligate themselves to put the interest of the public ahead of all other interests. And to give respect to that obligation, they concede any financial interest that might tempt them to relegate their public responsibilities. With that, let's get into the facts. Ms. Ramirez was recently elected to the school board of Flagler County. Prior to her election, she started a business that primarily offers adult clients phlebotomy training and medical assistant training. According to her, roughly 70% of her clients are adults. The other 30% of her clients are minors. For them, her business offers courses like a first aid course, a babysitting certification course, and medical camps. Her most popular course offering to minors is the babysitting certification course, and according to Ms. Ramirez, 90% of the minors taking that class are from out of the district. They're from a neighboring district. Ms. Ramirez doesn't have exact statistics, but anecdotally, she tells us that most of the minors taking the other youth courses are from out of the district as well. Qualitatively, this means that at least some of her clients are students from the district. The draft sets forth in question 1 to answer whether Ms. Ramirez's business may sell to students of her district. Consistent with your vote last July, question 1 now has 2 drafted responses, version 1A and version 1B. Version 1A recommends that there is a conflict of interest for Ms. Ramirez to sell to students of her district. Version 1B recommends there is not a conflict of interest. Before we contrast the 2 versions, let's compare their similarities. The first 6.5 pages of both versions are identical, and those pages take a lot of your feedback from the last meeting into account. Both drafts lay out the history of this commission's opinions regarding district teachers, school staff, and school board members selling goods and services to students. The commission was formed in 1974, and in its first 10 years, it issued 3 opinions, including CEO 80-35 that concern the sale of goods and services to students. And 3 times, the commission issued favorable opinions to the requester without ever analyzing the second part of section 112.313, subsection 7A. The commission issue-spotted other statutes to analyze, but did not recognize that section 112.313, subsection 7A might be relevant. In 2004, however, the commission changed its perspective on these types of scenarios. Starting in 2004, the commission began to recognize that some contractual relationships between district officials or district teachers and district students could compromise the objective pursuit of their public responsibilities to those students. To the best of my knowledge, the commission has issued 7 opinions since 2004 dealing with the selling of goods or services to district students. All of those opinions basically held the same thing. School district teachers, personnel, and officers cannot sell to district students if they have public responsibilities to those students. As applied to teachers and coaches, this meant they couldn't sell to students in their classes or on their teams. As applied to an ESE support facilitator at a middle school, this meant he couldn't sell to any students attending his middle school, given the breadth of his responsibilities extending potentially to every student at that school. As applied to a school board member, she could not sell to any students in her district because her responsibilities to student matters encompassed all students. That particular opinion is CEO 14-27, and it is discussed more fully in the draft before you. Like I said, both version 1A and 1B discuss all of the opinions in detail. That's how they're similar. Now let's talk about how they're different. First, version 1A. Commissioner Phillipson, last time you suggested that the staff employ a scalpel approach in answering and redrafting this question, and I believe we accomplished that in our drafting of question 1. We did that in version 1A by defining the space where a conflict might be found more narrowly. What version 1A does is it looks at whether a particular person has a public responsibility over students, and if they do, then it looks at the business to determine whether the business has characteristics that might tempt or might create a temptation to dishonor those public responsibilities. Prior opinions never explicitly recognize that some businesses might not tempt a public officer to dishonor their public responsibilities. Commissioner Lucas, last time you asked us whether the ownership of a restaurant might create the same tension on a school board member's public responsibilities as a tutoring business. Your point was well taken, and that feedback was included in the draft. The draft recognizes that not all businesses are going to be a source of a conflict just because they sell to students, but instead that there is a spectrum of businesses a board member could own that might or might not create a conflict of interest. According to the draft, on one end of that spectrum are tutoring businesses and art camps from our prior opinions. On the other end of that spectrum is Commissioner Lucas's hypothetical fast food restaurant. Version 1A stands for the proposition that it would be possible for a school board member to operate certain kinds of businesses, to sell to students in their district, but that Ms. Ramirez's business is not one of those businesses. The basis for this conclusion in version 1A is that Ms. Ramirez's business is very similar to the tutoring businesses and the art camps of our prior opinions, and it is dissimilar from the hypothetical fast food restaurant. Her students have to identify themselves for enrollment, like the tutoring businesses. Her services are provided personally, like the tutoring businesses. Relationships are formed, like the tutoring businesses. Ms. Ramirez provided statistics about her business that showed she served a relatively small client base in the last 2.5 years, like the tutoring businesses. To be clear, version 1A would not prohibit her from selling to anyone other than students in her district. Let's talk about version 1B. Version 1B concludes that Ms. Ramirez would not have a prohibited conflict of interest if her business sold services to students in her district because her business does not have certain types of characteristics that might tempt her to dishonor her public responsibilities. The characteristics of her business that version 1B focuses on are the ones that Ms. Ramirez's attorney focused on in her presentation to you at the July meeting. It relies on the fact that 30% of her clients are minors, and that 90% of those from her babysitting certification course are from outside the district, and that most of her clients from the other course offerings are from outside of the district. It relies on the fact that her business would remain healthy if she were not able to sell to district students. And it relies on the fact that, according to Ms. Ramirez and her attorney, there is no risk that students will be sources of repeat business because their course limitings are limited and there is no reason to repeat a course. Version 1B would stand for the proposition that under the circumstances where these particular facts are found, she would not be tempted to dishonor her public responsibilities to the students. In the strongest possible terms, the staff recommends to you that you adopt version 1A. Version 1A is consistent with the Commission's precedent, not some of the opinions, but all of the opinions we've issued over the last 21 years have come to the same or a similar result. Version 1A is reasonable. It applies a scalpel approach, like I said, by examining not just the public responsibilities of the public official, as the previous opinions did, but also the characteristics of the business. Ms. Ramirez's business comes out on the wrong side of that analysis in version 1A, but that analysis provides a metric that can easily be applied in the future. Moving on to question 4, briefly. Question 4 concerns whether Ms. Ramirez's business can hire teachers from her district. The draft concludes that she would have a conflict of interest under the second part of section 112.313, subsection 7A, because, as this commission has said in numerous opinions, all of them recounted in detail in the draft, if a public officer engages in private business with a subordinate over whom she has evaluation and recommendation authority or responsibility, an inherent conflict of interest exists. In CEO 14-27, the commission found that a school board member's private business could not hire a district teacher, even though the opinion acknowledged that the evaluation and recommendation responsibility was, quote, fairly rare. In a complaint context, you recently affirmed that line of thinking when you found probable cause in complaint number 22-044, which concerned the mayor of Quincy, who accepted a $20,000 loan from the city manager. Where the mayor had responsibility to evaluate the city manager objectively, she was conflicted due to her personal financial entanglement with him. The draft finds that the same is true for Ms. Ramirez. As a school board member, she has the final word on all discipline of teachers in the school district. She is unavoidably part of that workflow. Where she has the ultimate evaluation authority over all teachers in the district, the draft states she could be tempted to dishonor those responsibilities in situations where she employs them privately. Lastly, briefly, question 5. Question 5 concerns whether Ms. Ramirez can sponsor district teams in exchange for obtaining placement of her logo on the team's shirts. The first part of Section 112.313, subsection 7A, prohibits a public officer from having an employment or a contractual relationship with a business entity that is doing business with her agency. Ms. Ramirez has a contractual relationship with her own business, considering she owns it. That business would be doing business with her agency, considering it would be participating in a bargain for exchange of money for advertising. There are a lot of exceptions written into the Code of Ethics for conflicts of interest. None of them apply here. This would be a textbook conflict of interest. I'd like to emphasize that if you adopt this rationale, Ms. Ramirez remains free to sponsor non-district teams. She can sponsor the Little League team or the I-9 sports teams or the YMCA teams. She can even sponsor teams from other districts, just not teams within the district. For those of you who are new, this is not typical. There are 5 questions and they're all answered in the draft. Any one of them could have been a full ethics opinion on its own. And the draft has 2 versions, so there's a lot of material here to go through. There are a lot of ideas and analyses packed in here, far too many for me to be able to mention in this presentation, which is already running long. I hope that if you have any questions about the draft, you'll ask me. I present this draft for your consideration. I'm available to answer your questions.
Thank you, Steve. Any questions for, go ahead, Commissioner.
Couple questions, Mr. Chair. Thank you, and appreciate all the work by both you and the staff in putting this together, and also in our analysis of it. There's a lot here. On question 5, can you just talk to it was in another opinion I was looking at, there's a grandfather type clause where business relationship exists. I don't know if that exists in this case, but if say, her company was previously had logos and they're just looking to continue, they're not scaling, it's one of the other ones, they're not looking to scale it up or down. Does that apply here? Like, why would that apply, and why or why not?
It could. It could for current year advertising. So if she was already in a relationship with the school where she had logos on shirts currently for this year, right? I'm going to assume just for the moment, we don't have these facts, but let's assume just for the moment it's a year-to-year thing. If she had that agreement before she was elected to office, then she would have grandfathering available to her under Section 112.316. You read a little bit about that in the opinion to follow. Mm-hmm. That would be available for current year shirts. Going forward, however, new agreements, of course, would not be grandfathered. Grandfathering is only available to exempt or negate the conflict where out of the employment relationship and the doing business relationship and the joining of the agency is the last thing to happen.
And even if an extension, like I think in the one to come, there's talk of, like there's wording in the contract for an extension, whereas if it's just a default sponsorship, we would not, at least we'd recommend not to consider that a extension of the original contract?
If the contract called for an extension and the terms of that extension were called to be the same as in the original contract itself, then the grandfathering would be available. If it wasn't called for in the original contract, or if the terms were going to be different, your previous opinions would say that grandfathering is not available in that instance.
Thank you.
Mr. Chair.
Yes, go ahead.
While we're on question 5, Mr. Zukowski, as I understand it, this is the team shirts question.
Yes.
It basically opines that her company cannot, by a cannot have a logo on an athletic team's shirts, because that would create a conflict of interest. And the conflict is created because there, in the opinions writing, there's a contractual relationship that's formed when you when you purchase a sponsorship on a shirt. Is that essentially it?
That's essentially it.
Okay. I had two hypotheticals that I wanted to run by you that seem to maybe draw out a point that I'd like to make. The first one is, if the school were sponsoring a gala and you could buy a table at the gala, and by having it, you could host a table at the gala and they would put your business's name at the table. They would reserve a table for you, and you would be able to feed all the people that sat at the table. Under this opinion, that would appear to be prohibited, because you would be entering into a contractual relationship by purchasing a table. Is that what you're saying?
That's what I'm saying, yes.
And in a similar way, if the school were selling tumblers that had the school logo on it to support fundraising for one of the athletic teams, and her company decided to buy some of those tumblers, they would be entering into a contractual relationship to purchase that tumbler then, giving money in exchange for a product, just as they would be for a table or for a team logo on a shirt. Those would both be prohibited under your opinion. Is that correct?
For the second scenario that you present, which is slightly different than the first one, for the second scenario, as I sit here right now, I don't know whether staff would definitely find a prima facie conflict, as you're suggesting. In that instance, there might be some other exceptions available for something like that are written into one that I'm thinking of might be written into the statute. There's a less than $500. No, that's for things going out. The board also might 316 something like that if the board thought in its judgment, the board could apply 112.316 to negate a conflict of interest like that. 316 is available to negate a conflict of interest when the board finds that although there's a mechanical conflict, the reality of the situation presents itself in a way that there isn't actually a conflict to worry about. The board might be able to apply 316 in an example with the tumblers for all the reasons that I think before I interrupted you, that you were going to get to.
Yeah, I mean, essentially, I find it troubling that a company that is owned by a person who's sitting as a district member can basically have no involvement at all with the school through either sponsorship of a table, purchasing tumblers, or here having a logo on a shirt because of the Opinions Act application. And I think that the other two hypotheticals kind of draw that out. It all hinges on what is a contractual relationship. And in all three examples, there is no actual contract that's being signed or entered into. But the way the opinion is written, a contractual relationship exists when there's money exchanged, essentially.
Yes, that's right. I mean, and you know, at a fundamental level, that is consistent with general application of contracts law in the state. You don't need a written contract to have an enforceable one. And you can have a contractual relationship that's enforceable through outside of a written agreement. If there is a bargain for exchange and somebody does breach, then there are potential rights there.
Well, here's where I believe that the application of the term contractual relationship is overbroad. If I go buy a ticket to go see F1 in the movie theaters or go see a concert, every single ticket says this is a license. It's not a contract. So I'm giving money in exchange for something, entry into a movie, entry into a concert, but it's not a contractual relationship. And I think that the same would apply here, that these are not contractual relationships that are the subject of this opinion or the two hypotheticals I've given to you, just because there's an exchange of cash.
I would have to look, and I'm not warm on exactly the example that you give, but I would walk into, if I were to research that, I would walk into it with the premise that even if you're buying a license, you're buying property rights. And those...
A property right, I'm an eminent domain.
Oh, no, I know.
A license is not a property right.
Great.
So,
but I feel like... maybe not then, but I think
I'm just troubled with that opinion question 5 is overbroad in its application of what a contractual relationship is. And I hope that those examples, I'm not comfortable with opinion 5 for that reason, or question 5 and the answer to question 5, because I just think it's taking too broad of a brush for what a contractual relationship is. And I didn't see anything in the opinion that cited to previous opinions saying that a contractual relationship exists just because there's an exchange of cash.
I mean, the draft stands on the proposition that if there is a potential for if there's a relationship where there are potentially rights against each other afterwards, then we're going to find a contractual relationship there. And that's been, and you read the opinions that cite to that.
Okay. That was it as to question 5.
If I can just chime in real quick on question 5, and not to argue with an eminent domain attorney, because licensing contractuals, it's not really what I do, but I do see a distinction between, that was a great example, by the way, makes people think, which is always a good thing, is the purchasing of a tumbler versus continuously purchasing tumblers every month, 50 batches at a time. So that, to me, would rise to the level more of this opinion. In other words, putting the name on the T-shirts, it's like a constant, ongoing transaction, so to speak, versus going to the movie theater and buying a ticket, buying some tumblers. If a company were all of a sudden enter verbal, I'm going to buy 50 tumblers from you a month, I think that would be problematic versus buying tumblers one time, which may not rise to the level of a contractual relationship, so to speak. But the ongoing T-shirts, name on it, she's an individual who chose to run for office. Let's keep that clear. An individual who chose to run for office is still engaging in some type of contractual relationship with individuals who are really subordinate to her. To me, that becomes problematic, or at least opens the door for problems.
To expound on the point that I was trying to make earlier, I think out of the two examples that we got about the tumblers and the gala, the board would be within its authority to apply 112.316 potentially to the tumbler situation for the reasons that you say, and that I left unsaid earlier. But the fact that it's not likely to create an actual conflict of interest, it's an instantaneous relationship, it's not going to be publicly available, the purchase of the tumblers doesn't necessarily, unless your mileage is going to vary based on facts, but doesn't necessarily touch any of the responsibilities of a school board member, because that, the sale of tumblers doesn't rise to probably to their domain. So there are differences there. With the gala, however, it's a very visible transaction. There's more money involved. The board might be right to say a situation like that could rise to the purview of a board member and might reflect on their responsibilities and therefore not apply that exemption that I was speaking of.
Thank you. Commissioner Ellison?
One follow-up question. You were talking about the situation of after the transaction, should it not go through properly? Say there's a conflict of, in that situation, let's, for example, they buy the sponsorship of the shirts, it doesn't go on the shirt. They play a full season. Wouldn't she have a right to pursue some sort of remedy, probably small claims on this basis, but some remedy for that versus some of the other transactions? There might be, but it's a little bit more de minimis.
I would think it is possible that if the school board doesn't give exactly what she believes she bargained for, then it puts her in a position where she is an adversary to her own agency, which is exactly what the nature of the conflict potentially could be. And that's why the legislature, in its wisdom, created this statute to say, if you have that mechanical dynamic in place, you have a prima facie conflict. They recognized that not every situation where that mechanical conflict is in place is going to necessarily devolve into a conflict, an actual conflict. So they wrote directly into the statute about a dozen exceptions. And then we, as a commission, have probably inferred another half dozen through our opinions. I don't believe any of those apply to the situation that we're discussing here. So the answer to your question is, yes, it would set her up to be potentially opposed to her own agency if things didn't go exactly right, and then she's left to either pursue it or not. But that decision is exactly what the tension is.
And with this opinion, we are focusing mainly on the sponsorship of a team, correct? In this one, so similar you mentioned earlier about the spectrum here. This is on the team. Should the board have something come before it, let's take the Tumblr example, that we could analyze independent of this based on those facts, and that this opinion is limited to sponsorship of athletic teams?
That's exactly what it is. It's limited to exactly what it's talking about. We're talking about the sponsorship of the athletic teams within the district. If she felt strongly about it and she wanted to donate the money, right, not in exchange for anything else, she could totally do that. She could donate the money to a district team. We've said that a donation is not doing business. We've said that emphatically several times. We said it just last year in an opinion. We could do that. She could donate or sponsor the money. She could sponsor teams elsewhere outside of the district. But within the district, it puts her in a position where there's tension and a potential opposition to her own agency, which presents exactly the conflict that we're talking about.
And I think Commissioner Bain's example of the Tumblr is a great one. And one thing could we do with this opinion is, as fellow lawyers like to do with judges do at times, is put limiting language of this is based on these specific facts presented in this scenario.
We've done that before. It is implicit with every opinion that we write that because they are binding advice to the requester, the facts necessarily matter. That's why we get so many facts, and that's why we give it as close a review as we do. We could make that explicit here. That would be easy to do, and like I've said, we've done that before, and I believe this composition of the board has had us do that before.
Thank you.
Thank you. Any other comments? Commissioner, sorry.
Thank you. Sometimes I have to stand up and be seen. I have a question that has nothing to do with baseball. If a PTSA has decided they want to encourage students to participate in a babysitting certification, unsolicited by this particular teacher, they want to put her name along with others on a list of where people can go to get that certification. So in number 5, is that not possible even when she does not solicit it?
So the opinion doesn't bind the PTSA, to be clear, right? So the PTSA can do whatever it wants to do. But the opinion would go to the public officer here, Ms. Ramirez. What it would tell her is she would not be able to make those sales, even though it was coming from a good-natured place like the PTSA. She wouldn't be able to make those sales, not because the sale is not good-natured and she's not well-intentioned, or that she might, we're not impugning her character, as we wrote several times in the opinion. We're not saying that she doesn't have the strength of character to resist these temptations. It doesn't matter how the sale originates. But once she's in a relationship with a student, a customer relationship with a student, there is some tension, maybe not for her, maybe for somebody who has a similar business or a business that's similar to the similar business. And as you go along that spectrum, right, there are plenty of businesses where somebody might be tempted to do things in their public role to maintain a harmonious relationship with that customer so that it remains profitable. And once you have a customer, you want to maintain that customer relationship. That's good business sense. The code kind of assumes that people are going to have good business sense, but it puts guardrails on that to say there are certain things that you can't do, and one of the things you can't do is you can't put yourself in a situation where you might be tempted to put that business sense ahead of your public responsibilities. We wrote in the opinion that the public doesn't need to have to hope that a public officer will refrain from acting on a conflict of interest because they're entitled to somebody in that office who was free from a conflict in the first place. The statute's entirely preventative. It doesn't assume that she's going to do something. It recognizes that she could, and that's the nature of the prohibition that the legislature wrote. And as I said earlier, the 4th DCA said it was very precise in fulfilling its broad function.
No follow-up?
Well, I thought that the whole point is whether they solicited or didn't solicit. And if you did not solicit, I don't know how that could be a violation.
question, in the last draft that you read for July, the marketing question and the selling question were kind of collapsed into each other. We separated those out for this draft because they are really separate questions being asked. On the marketing or soliciting of the business question, we've said, and Ms. Ramirez through her attorney, they looked at what we did and they agreed that she won't be able to market inside of the schools or using school resources. She won't be able to market her business. She can buy billboards on the outside. She can advertise in the Penny Saver magazine. She can advertise in the newspaper. She can market generally, globally. She won't be able to market inside the schools to the students. That's a separate issue from the selling question. The selling question is asking, will she be tempted to dishonor her public responsibilities that she owes to each student necessarily by being a part of the workflow in disciplinary stuff or accommodations requests, expensive ones, or just being a public officer who has to do constituent services. I think we all understand how many phone calls a school board member must get from parents who have been trying to get a particular outcome for their students and necessarily have escalated it to the top of the food chain of a school district. They get a lot of phone calls. And where a school board member's attention may be put, it might be put more freely towards an issue that affects a customer or a situation where they want to maintain a business relationship. And so that's the worry and that's the concern about selling to these students. It's not that, and again, it's preventative. It's not that she will, it's that she could. And the legislature wrote a statute that said if she could, then she can't.
Any more comments or questions? Oh, go ahead.
Sorry, man, you still, sorry. I'm still struggling on, thank you. I'm still struggling on 5 on being possibly overbroad. So same school board member shows up to school football team for one of the schools that falls under the district, buys a ticket to get in. We think she's okay to buy a ticket to attend this football game because everyone's buying a ticket. Is it a contract? I don't know. But I don't think, 316, maybe we're in practical, probably not a problem. She buys a hot dog at the stand. She gets sick. She now sues the school board, didn't prepare, so I mean, are we going down a path of a school board member can't, and I think it's a question more for the commission because it's a spectrum, and the spectrum I see us ruling on is man, that school board member better not attend a football game and buy a hot dog because if they get sick, they shouldn't be buying, and then I look at, okay, what's the practical, I'm paying, it's am I walking up and paying a fee to put my logo on a shirt like anyone else would? What are the odds of that reaching contention? And we're talking, any of them potentially can, and I think we have to just decide where we fall in that spectrum, but it's very nuanced is what I would say. I don't even know if I need an opinion on that, but if you have one,
I do, because I disagree with your premise entirely.
That's okay.
The example that you're using would not even be a first part of 7 conflict, and the reason for that is you need to have a public officer who has a contractual relationship with a business entity, and that business entity is then doing business with the agency. In the example that you provide, we don't have that triangle, the dynamic that's prohibited. We have a public officer buying something or entering into some sort of arrangement directly with their agency. There might be a second part of 7 analysis somewhere there for some other set of facts. But for the example of buying a hot dog, there is no business entity there in that, so that's not the prohibited dynamic.
And just to be clear, as Commissioner Phillipson put, we can have limiting language on this, correct? That only applies to the facts before us, right?
Yeah, we're only analyzing here
What was given to us.
what was given to us and even the facts that she provided to create the scenario. So what we have, again, for those facts, just so we're clear, is she used to do this, she then got elected. The schools offer an arrangement where you can pay a sponsorship, and you get logo placement. At its core, that is advertising, that's a service that has value. I don't think any of us think it doesn't. That has value, and it's a smart business decision to do in the abstract, but she's a public officer, and we've identified that for public officers, they can't have that type of arrangement with their own agency. She could do it with, like, if there was another agency, she could go and do it with them, if there was like another district, for example, just not her own district.
Mr. Chair, I agree with the recommendation to limit this question to the facts of this case. I would also suggest that we add a sentence or a thought that we do not opine that all payments of money constitute a contract or contractual relationship. Because I think that's my concern, is that any possible payment of money could be interpreted under this opinion as creating a contractual relationship. And it just is way too overbroad of a statement, in my opinion, to say that just a payment of money constitutes a contractual relationship.
I think that is, and I think I agree with you, looking for common ground. I think I agree with you to the extent that if there isn't a contractual relationship, the payment of money alone is not that, right?
Okay.
Like, I think our opinions do say multiple times, and I don't necessarily want to recede from the idea that bilateral consideration is not a contractual relationship. I think that would be potentially something that we would want to explore in more than just a footnote. But I think for the premise for today, what you've said is technically accurate, but I wouldn't want to extend it beyond exactly the words of what you're saying.
Yeah, you currently have the language that limits it to the facts in the opinion. You say under the particular factual circumstances, we determine the placement of your business logo would constitute consideration in exchange for your business's sponsorship. So I think you've got that limiting language there.
Yeah.
That limits it to the facts. But I think if we could just go one step further to say that we do not opine that any payment of money constitutes a contractual relationship, that it would depend upon the particular facts.
Could we say something of payment of money is not a per se contract?
Yeah.
Just so then we're not even getting into
Or prima
the consideration.
facie,
Yeah.
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 Okay.
I think relying on the good advice that I get from my team, I don't think nothing jumps out at me, nothing jumps out at anybody else. So having multiple eyes on this, I think we can do exactly what you're suggesting.
Okay.
And I think the fact of how long it's taken to discuss this, I think, speaks for itself on the inherent nature of the conflict. I mean, that's obviously something that we're trying to navigate through. So at this time, if anybody has any other comments, we can.
Yeah, Mr. Chairman, sorry.
Oh, go ahead.
Back to 5, because, I mean, she could be bringing several of her company people with her and buying those tickets and that food. Like, you don't know we wouldn't know, it's a hypothetical situation, but it's potential that the business is buying tickets to an event. And I mean, it's not, $5 ticket, maybe 3 employees are there. In the realm of spectrum, it still can fall there, potentially. I mean, that could be a bit, if she's using her corporate card to buy 2 football tickets and 2 hot dogs for 2 of her employees, we're
Sure.
back in the spectrum.
Yes, and we are probably in a problematic zone at that instance, because she necessarily owes a duty to her own company, right? And she owes a duty to her agency. When the two are put in a situation where they could potentially be adversaries, we don't know which one she's going to pick. And the public is not supposed to be able to have to just hope that she chooses right. She's not supposed to put herself in a situation where the two could be opposed in the first place. That's the whole point. It's entirely preventative, and there are certain things that necessarily happen when somebody becomes a public officer that they have to forego, as the nature of public service and subverting private interests for public interests. You all have done it. Like, there are sacrifices that some of you have had to make, certain clients that you can't take, for example, that might appear before us, for example, things like that. So this isn't something new. It's just as applied to the school board member in this situation, it's new, which is why we brought it before you. And I think we were right in that the amount of conversation it's generated. But, with somebody who's buying tickets and hot dogs through a corporate card, through their business, if they wanted to get your advice on it, they could. We would definitely put something like that before you, because it's even that is different than some of the other things that we've seen. So you would have your shot at it eventually.
I mean, it's closer to the Tumblr situation, I would say, but.
Yeah, and you might or might not. I could even see a scenario where you might apply 316 to one and not the other, for example. I could wrap my head around that. It would just depend on exactly the person before you, the facts that they're bringing, what their position is. Even among school board members, different school board members have different workflows where they have different responsibilities amongst them, depending upon their charter. So it's not necessarily the case that you are always going to have an apples to apples thing, which is exactly why, as we said, these are limited to the person requesting it. It's binding advice to them. If their facts match, it insulates them from a complaint later on those facts, if the complaint is about those facts. So that's why we're here.
Go ahead, Commissioner.
I have a question for you, Chair.
Mike?
Are we voting on these questions individually? I would assume yes.
Yeah, honestly, I mean, if they were split up, for the simplicity of dividing, breaking it down for analysis, or is it one?
My understanding of it was the last draft as a unit, and in this one too, there's a lot of ideas here, and there's a lot of things going on, and although we separated it by headings, question 1, question 2, question 3, necessarily a lot of it was pointing back. What we did here, I made sure not to have anything pointing back, and we separated them visually so that each one could kind of stand on its own, and you could digest them even remotely in time if you needed to.
So what you're asking is if we vote on them individually, is that what you're asking, versus
I
as
just
a
want to
whole?
make a motion.
Okay, no, I was about ready to, I was gonna actually.
I would like to, and if you think this is procedurally incorrect, stop me, but I would move to adopt the opinions in questions 2, 3, 4, and 5, with the exception of the 2 instances of limiting / additional language for question 5 that have been proposed. So that's my motion. With.
Yeah.
I'll second.
Any opposition?
If I may, one last thing.
Go ahead.
This is just institutional experience where I had a board a couple years ago that did this, where they voted on some of the questions and then reached an impasse on the others. And there's an even number of you here, so I'm worried. And when they reached an impasse, they adopted some of the questions, tabled the rest for next time. Then when we got here, so the advisee went on to go and do things, and this was involving masks, the uses of masks and GoFundMes at Broward schools, and you might have heard about it in the news. And I gave the opinion for 2 hours on it. And when the board got back, they then rescinded their approval of the previous decision, the previous one. So I would ask that you don't walk out of here today giving partial approval on something, because it might put Ms. Ramirez in a situation where she can't back out.
I can fix this. I was trying to increase efficiency, and I had the exact opposite effect. So I'm going to withdraw my motion. Can we talk about 1?
Yes, please.
Okay. Anyone?
Anybody get a motion for accepting staff recommendation for 1A with the limiting language?
Oh,
Sorry.
Well, that was for 2 through 5.
Nope.
Now we're taking.
Oh, I'm sorry,
Wait.
sorry. Hold on.
we just haven't discussed 1, and I think that was probably the one that was anticipated would generate the most discussion, since there's 2 different versions.
I thought the floor was open to all of them, and everybody was
Yeah.
focusing on
Does it-
marketing.
Does anybody well, okay. May
I
I-
thought, I apologize, I thought I opened the floor for discussions on all questions.
Yes.
We just honed in on marketing.
Through the chair, may I ask a question?
All day.
Okay. For 1A, I read that opinion to say that if Ms. Ramirez has young children, and she has a next-door neighbor who's a high school student, and she's known her whole life, she can't hire that high school student to babysit her children, or mow her lawn, or wash her car. Do you agree with that?
I have a daughter who's in gymnastics, and they do a coffee fundraiser.
She's really good at it.
I'm obligated to, for that team, I'm obligated to sell 35 bags of coffee, and the coffee's not cheap. And every other parent sells that coffee in their office, but I don't because I have supervisory authority over everyone here. And if I were to do it, the first 4 people that would buy would be these 4 right here, because why wouldn't they, right? And I don't think that that's, you know, they would be hoping that I might show favoritism potentially, right? And why wouldn't I? Because they essentially helped me out in a financial relationship when I needed it most. And so I don't sell coffee in the office. I'm dying to, but I know better. And I think it's the same here. It's, you know, again, it's a well-intentioned situation, right? Where the public officer means no harm by hiring a babysitter that's also a student. But even with the coffee, something as insignificant as that could create situations where I'm showing favoritism to one employee over another. I put my public responsibilities ahead of, I relegate my public responsibilities to evaluate them objectively, and it becomes a problem. It becomes a problem that could metastasize. And so, no, she wouldn't be able to under this opinion. She wouldn't be able to under the other opinions that we've done for the last 20 years either.
I guess that's why the limiting language in question 5 is important.
Go ahead.
What helped me process 1A and 1B, and I'm offering this because I agree with your recommendation on 1A, and that is that as a lawyer, if I undertake to represent a client and another lawyer in my firm wants to take another case that may be adverse to that client, he's conflicted out or she's conflicted out because of that. And in my mind, what helps me approve of 1A is that the district member has undertaken representation of the district as a member of that district, and that is her chief obligation, is to serve that district above all else. So whatever private or non-private conflicts might exist, they fall by the wayside to her duty to that district. That's the primary duty. So that helps me to swallow the bitter pill of 1A. And to me, it's a bitter pill. I don't like it, but that's the practical effect, in the same way that you can't have 2 lawyers in the firm, one working for and one working against on different matters.
I'm not saying it's not a harsh result,
Yeah.
right? We as staff, we take dozens of phone calls daily. We're constantly telling people no, and we're kind of numb to it at this point because we just want to keep people safe, and our job is just to promote trust in government and do an accurate reading of the Code of Ethics and the opinions as you've given us. So we're kind of used to that harsh result. I don't mean to present myself as numb to it, right? I understand completely what this means, but I think your reading of the opinion is correct, and you know, the duties that are owed are paramount to the private ones, and this is just the natural consequence of that feeling that the legislature had when it made the Code of Ethics.
Yeah, I don't like it, but I think that that's the right thing.
Mr. Chair?
Yes, go ahead.
More than one. We had talked a little bit about like the difference between a restaurant that students eat at versus what sounds like a one-time course that's not very tied to their academic performance. Would you extrapolate the relationship to the student's siblings who may not be in the school or may not be in the school yet or may not be in the school anymore? Would you extrapolate it to their parents, their grandparents? Like, it just seems like it gets really overbroad if you're looking at it with this lens super fast, that no member who serves as a part-time school board member can have any type of business in their district whatsoever because students are involved. I mean, that's where I think we go if we rule this on 1A. Like, you can't have a business that serves anyone in your district in pretty much any tangible. I mean, maybe their grandparents are in a retirement home, and like it gets broad really fast.
Steve, you have a response for that, or?
I do. I will say and if it's not clear, the opinion does not go to any of that. The prior opinions do not reach that, right? And so again, that would be something that's kind of maybe a little bit more free from the precedent than what we've got here. What we're talking about is selling to students. The other opinions, they do use the phrase selling to students and parents, but what we're talking about in those opinions are art camps and tutoring services where if the parents are involved, they're only involved in so much as they're purchasing something for the kids, and the kids are the ones that are actually buying the service, right? So that's the opinions, and that's where this one goes. We're talking about selling to, like if the parents wanted to go and buy phlebotomy services, I don't feel like this opinion reaches that necessarily. If you guys want to go there, that's fine, but I'm not recommending that.
What if it's phlebotomy services for their kid?
Well, yeah, if you read, so if she has a phlebotomy class for the kids, I believe, and she has a first aid class, and she has a class that's called Stop the Bleed, I believe.
Or could a pediatrician be on a school board?
I'm sorry, say it again.
Can a pediatrician be on a school board? I'm sorry.
No,
I've had a
I
really
think
long week, and I've been yelling at people in depositions literally all week. I'm sorry, Steve.
you all could not do more than I've been doing to myself over the last couple of weeks on this, honestly.
You don't have to answer me.
I inhale deeply only to buy myself enough time to wonder about what a pediatrician might be tempted to do and what their job looks like and how it might interact.
You don't have to answer.
I don't have those facts,
not
and I've not
gonna
thought
change
about it. But what jumps out at me with a pediatrician who has a service that is, at that point, unlike Ms. Ramirez, it's predominantly going to kids. Like, even if you were to adopt version B, the pediatrician doesn't have half the facts that Ms. Ramirez is relying on to get to version B. The pediatrician might actually be on the spectrum that version 1A talks about, might even be beyond where the tutoring businesses are.
Mr. Commissioner, yeah, just the art camp and the tutoring, I think, are the most applicable because you have the same type of thing here. You have it's essentially a babysitting camp, or a babysitting class, or so I see the parallel there.
Yeah, and the tutoring, some of the tutoring opinions even go to the fact that it's non-remedial, like the service that she offers is non-remedial. So it's an instruction, a non-remedial instruction, just like some of the other tutoring opinions that we already have.
Yeah, we're not saying that she can't open up a Burger King and sell burgers to people. It's just that it's different from that.
No, if she wanted to, if it was a Chuck E. Cheese operator, like we suggested last time, I think the Chuck E. Cheese operator would probably be free to join the school board, run for school board, be on it, and sell pizzas and arcade services to kids because in order to show favoritism to somebody in the first place, you necessarily need to know who they are and what might motivate them to continue doing business with you, right? And you never have to identify yourself to buy a pizza at Chuck E. Cheese or to play Pac-Man there. And so they would never even know to show favoritism to a student because they don't know who's coming in. They've got tens of thousands of people coming through annually, and none of them have to enroll or identify themselves. And so you wouldn't be worried about them showing favoritism in a situation like that because they don't even know who they got. And so that's very different than the pediatrician where they enroll, they got these people's medical records, they know them intimately, the relationship is even more formed than what Ms. Ramirez has got. Very different.
Steve, wouldn't the pediatrician, not to go on that, but I enjoy that, it's pretty interesting. Wouldn't the pediatrician fall under the grandfather clause? Because they were obviously their patients before they got into school. And the younger siblings, you'd have to get them before they got into school so you can have them with grandfather on as well? I'm just kidding.
No. This is actually
because I'm
really
wondering,
good.
it's actually an exercise.
No new patients.
This is the type of information that I like.
No, but the patients,
I
the
wish
new
we got to
patients
do
can't
more.
come in because presumably they'd be underage, they're not in school, so they don't fall under your district.
The reason why 316 would not apply to institute grandfathering is because you have said many, many times in multiple opinions over decades, 112.316 does not apply to the second part of 7. Here's why. The second part of 7 is we're looking at not a particular dynamic that stands in place of a conflict. We're looking at the reality of the situation. We're looking at all their facts and we're saying, all right, this person would be conflicted to put their public responsibilities below their private ones. 316, the exception for 316 says, understanding that there might be a technical conflict, the reality of the situation is that there isn't a prohibited conflict. So you can't say that the reality says there isn't one if the second part of 7 is looking at the reality to say that there is one. That's why we've never applied 316 to negate a conflict under the second part of 7. So no, we wouldn't grandfather in that instance because the whole point of finding a second part of 7 violation is that there is a conflict in reality.
Understood.
Mr. Chair?
So, yes,
More on the Chuck E. So not a Chuck E. Cheese, pizza restaurant. You see the family come in every Friday night. You do see them. They're not putting their name in. They're paying cash. Like it's really close. It could be really close depending on how involved you're there. And I know we're not asking that question, but back to the parents. Like the school, this business. I think you said, or they said to you that 70% of the students are actually adults who take the classes. So, I mean, it is very possible. I know they're not asking, I think, on parents, but if some of those students are, a small percentage are in this business and more than twice the number of kids are, as you know, are people are adults, then probably some parents are in there with the same last name. So, I mean, it gets...
I'm really glad you asked this question. I think that this is important because they made the same or similar argument, and really, version B relies on this like as a bedrock.
Yeah.
If you look at the previous opinions with like the coach, for example, right, where the coach coaches a district team, and then they can't do private coaching outside, we said. They can't do private coaching of the kids from the district. We're not asking whether or not that private team that they're coaching is made up 100% of their district team, right? We're not even saying that the private team that they're coaching on the outside for money is mostly kids from the district. We said it didn't matter what the percentage was. You couldn't have any of those kids because your obligation to any one of them could be compromised. And that kind of makes sense that we didn't draw a line because imagine trying to draw that line. What percentage does and doesn't tempt you to dishonor your public responsibilities? Any court would find that line that you drew to be arbitrary. Mm-hmm. And so that's why the previous opinions never did it and why I'm not recommending that today. I think B is all the arguments that they asked for and that you implicitly asked me to draw out in a draft, but B is flawed for that reason. B is also flawed because, you know, I know that they're saying that there aren't, they said it from the podium several times, they said it in the most recent response, there's no risk of repeat business here. But they offered us a lot of letters of support here in the materials that they provided. There's at least 4 or 5 references to kids taking multiple courses or families where the sibling, the older sibling or the younger sibling should or would or plans to take courses. There's a lot of monetization of these customer relationships for future potential profit here. You know, it's not just a one and done, as the customers are saying themselves. And so I think that's another fact that B relies on, that I'm not here to question their facts. I'm not saying that there's a candor problem. But what I'm saying is I don't know that B is everything that they wanted, but I don't know that B is the right vehicle to insulate somebody from a complaint, because if a complaint came in on their facts and we got to investigating and then we found out, no, there's actually a lot of repeat business and the opinion says the absence of any one of these factors would be problematic, I don't know that B's the vehicle that she needs to actually be insulated from a complaint, because I'm worried that there's maybe an overly rosy view of their own facts. I don't know, but the customers are saying it.
Just to follow up on one that I know it's not asked, but given the direction, we would likely, if they ask, well, what about parents or what about siblings, we would probably say, you think that would follow in with 1A as well? Like, can a parent take a...
I don't know about siblings.
I'm sorry?
I don't know about siblings. I think parents are probably fine, because I don't think they owe a particular obligation to the parents. Maybe, maybe not. We weren't asked. I didn't answer it. if we got that, you would totally get that question. You know, I don't want to lock myself in a year down the road on something because the facts are going to matter, and I guarantee that you're probably going to see that now because this opinion it's a hot topic. You'll see in the next executive director's report that just 2 weeks ago I did a presentation for school board attorneys down in Fort Myers, and there were, I don't know, 100 of them there. And this was, you know, this was something that was interesting to them. You know, some people asked me, hey, what's going on with that opinion? You know, and it's on the minds of people because school board members are necessarily titans of industry in other fields, and they have activity in the community, and they're tied into the community, and so this thing does matter. But I think implicitly everybody understands that you can't just continue operating like you were before and everything should go along as if nothing has changed. Something has changed substantially. There's a public interest that now takes primacy above all others, and that's what 1A recognizes.
Any more?
I'd like
Yes,
to make a motion. Can move to approve 1A with questions 2 through 5, with the 5 having the caveats we put on the record today.
Second.
A second? All right. Let's try it this way. Any opposition?
Yeah, yes, opposition, nay on the
Nay.
motion.
All right, so let's,
It's a trick question.
all those in favor, say aye.
Aye.
All opposed?
Nay.
Nay.
I think we have I think the motion passes. Thank you.
Thank you.
Can I thank the staff again for all the work
Yeah,
that you put
thank
into
y'all.
this? You guys did a tremendous job. Thank you.
Good work, Steve, and staff, of course. All right, item number 5, consideration of advisory opinion. It's going to be filed 2821. Next is the consideration of advisory opinion filed 2821. Are there any members of the commission who need to make a disclosure regarding this matter? Is the requester in attendance? Thank you. All right, the floor, commission recognizes Michael Terry. You may present the draft opinion.
Through the chair. Before you is file 2821. Like the opinion you just heard, this opinion deals primarily with section 112313, subsection 7A. Unlike the last one, this opinion focuses on the first clause of the statute, which says that if you will have a prohibited conflict of interest if you are in a contractual relationship or an employment relationship with an entity that is doing business or under the regulation of your agency. In this case, Mr. Cervera recently became a member of the Broward County School Board, and he is also employed as a non-equity partner by a law firm that is doing business with his agency. The law firm holds multiple contracts to perform legal services for the school board, and these fall into 2 categories. The first category is the Special Counsel Services Agreement, and that's a multi-year contract with 2 possible extension periods. The second are litigation contracts that are entered into on a one-off basis. So before we get into the discussion of Section 313 and 7A, we should note that because Mr. Cervera is a partner in the law firm, even non-equity partner, and the law firm is selling services to his agency, it would appear that he does have a conflict under Section 112313, subsection 3. And that statute has a clause, it's a 3D, that expressly grants grandfathering to contracts entered into prior to the beginning of the public employment. In addition, the Commission has also applied that express grandfathering to extensions that are contemplated in the original agreement where the terms remain the same. So grandfathering will negate that conflict under 3A, or under 3. Next, these contracts do fit the definition of doing business under Section 7A. And because of his employment relationship with the firm, Mr. Cervera does present a conflict of interest for both of those contract types that I mentioned. Now, fortunately for Mr. Cervera, there is an exemption that can be applied to negate the conflicts created by those conflicts that were in place prior to his appointment to the school board. And the Commission on Ethics has a long history of applying the principle of grandfathering to contracts that were in existence before before the individual took on their public role. So as to the contracts that existed, before Mr. Cervera took office, the grandfathering will apply to negate those conflicts. Now, the Special Counsel Services Agreement has 2 extension periods, as I mentioned. They were included in the original agreement, and the Commission has held that these extensions do constitute new agreements. However, the Commission has also held that as long as the terms of the agreement are the same as in the original agreement, and it was contemplated in the original agreement, that the grandfathering can continue to apply throughout the extension periods. Next, Mr. Cervera asked whether his law firm could enter into new litigation agreements with the school board without creating a prohibited conflict of interest for him. And the answer to that question is no. Those would be new agreements not tied back to an existing agreement where something like a simple extension was contemplated. Grandfathering would not apply in that case. And this dovetails into the final question that Mr. Cervera asked. He asked if he would have voting conflicts that would require him to abstain or avoid participation in votes about contracts that would be considered under the grandfathering. And the answer to that is that he must avoid voting on matters that could inure to the special benefit or loss of his employer, the law firm. And to put that more simply, he must abstain from voting on any measure that would create or remove a billing opportunity for his firm. So, Mr. Cervera can absolutely participate in discussions, and he can even ask questions for the purpose of maintaining his informed status as to important matters before his board. So to summarize, Mr. Cervera will benefit from grandfathering to negate the first clause of Section 313, subsection 7A, and we did not find any facts in this that would lead us to the implication of the second clause. So Mr. Cervera does not have a prohibited conflict of interest as it pertains to the agreements and the extensions of the Special Counsel Services Agreement or the existing litigation agreements that were in place prior to his joining the school board. Likewise, the conflicts under Section 112313, subsection 3 are negated pertaining to those agreements. Next, his law firm cannot enter into new litigation agreements with the school board without creating a prohibited conflict of interest for Mr. Cervera. And finally, he must avoid voting on measures that would create or remove billing opportunities for his firm. And I present this draft for your consideration, and I am available to answer any questions.
Thank you, Mike. Any questions? And the requester's not here, correct? Can I get a motion?
So moved.
To adopt the staff's recommendation? Second?
Second.
All in favor? Aye. Any opposition? Thank you. The motion is adopted. Or the draft opinion is adopted. Thank you. Item number 6, consideration of second order on request for extension. Item 6 on the agenda consists of a request for an extension of time to which to file a financial disclosure statement. The law gives the chair the authority to grant extensions of 45 days, but only the commission can grant longer extensions. This is the second request for an extension by Mr. Richard Jafrida. Did I butcher too bad or not too bad? Hopefully not too bad. The draft order granting the request is in your materials. If you have any questions, Stephanie can present her recommendation. Otherwise, I'll be happy to take a motion on this.
Move to approve?
Second.
All in favor?
Aye.
Any opposition? None? Passes. Thank you very much. All right. Consideration of litigation expenditures. And with that, I turn to Carrie.
It is I. Thank you, Mr. Chair. This is a matter where I'm seeking your approval to expend funds should the litigation costs for the Owens case exceed my $10,000 expenditure authority. This arose out of a case where probable cause was found. It was sent to DOA, and while it was at DOA, the Respondents' Council filed a motion in circuit court and is seeking to keep the commission from being able to proceed with its case at DOA. We have engaged the Office of the Attorney General to represent us under the ongoing litigation contract that we have that's separate from the advocates. And it's my understanding there's been a motion to dismiss filed in the court case. So in an abundance of caution, I want to be able to pay any legal bills that come in, and I ask for approval to do so.
Is there a motion?
So moved.
Second?
Second.
All in favor?
Aye.
All right. Any opposition? Hearing none, motion passes. Thank you, Gary. Consideration of 2026 legislative recommendations, item 8. This is a continuation of the discussion of what will become our 2026 legislative recommendations. You have a memo in your materials outlining a number of possible recommendations to discuss. We are not limited to the discussion of those items on the list. Before we begin, are there any members of the public who wish to speak on this matter? Thank you. I'll recognize Ms. Stillman to provide some additional detail regarding the items in this memo.
Thank you, Mr. Chair. You all are familiar with these from your discussion at the last meeting. What we did was we added some draft language for some of the proposals. Today, we're not asking you to necessarily adopt that draft language, as you know, members of the legislature and their staff often draft the bills, but sometimes we are asked for our input on that. But to the extent that the draft language might further discussion and you all might have some input for staff on it. I'll go, I guess, maybe one by one, so if there are any questions about them, we can have a discussion while we're on that, and then once we get through all of them, you all can decide which ones you'd like to proceed with. I think I'll stick to the substantive ones first, and we'll talk about the technical ones after you've sort of moved on the issue. The 2026 committee meetings will be upon us in just about a month, so it's important that we decide what your priorities might be. The first two that we'll talk about were your priorities the last year. The first relates to gift acceptance and disclosure. This was something that was brought by a member last year and would change the definition of relative for purposes of the gift law to include foster parents and foster children. Not all foster children are adopted, but they can continue that familiar relationship on into adulthood, and should they be included in the definition of relative, then public officers and employees who file Form 1 and Form 6 and have an obligation under the gifts law would not have to report gifts that they received from their foster parents or foster children. So they would enjoy the same benefit that biological parents and adoptive parents currently enjoy. So with that, I'll leave that to you all to ask any questions or have a discussion, or we can move to the next if there's a good understanding.
Yeah, I think we can move to the next. Pretty good understanding on that. Yes, all right, Carrie, thanks.
Okay. The next one relates to the whistleblower protections. This was an item that's been on the Commission's recommendation list on and off for a few years. Last year, we did have a bill in the House and the Senate. Representative Benaroche sponsored in the House and Senator Gates sponsored in the Senate. Those bills were not heard, but don't be undeterred. It would not mark the first time that ethics legislation didn't pass at the first time. I'm not an expert, but I think many bills take a few tries before they get through. The notion behind the whistleblower protection would provide protections to employees who file ethics complaints, who are public employees. These folks are closest to the things that are going on. They are the ones who might have personal knowledge and information other than hearsay to file valid ethics complaints with the Commission. Among the goals, I think, of the personal knowledge and information other than hearsay is to make sure that the Commission is, looking at the right things. And currently, the way the whistleblower law is written, we don't believe those protections extend to certain individuals who file complaints with the Ethics Commission. So if there are any questions, any discussion, or if you would like me to proceed.
Does anybody have any questions or, seeing none, you can proceed, Gary.
Okay. Moving on to personal knowledge and information other than hearsay. Throughout the last year, members have talked about this issue quite a bit, so we put some items on your list for you to talk about in terms of possibilities and whether or not you wish to pursue anything on it this year and want to wait to see. One way to approach it would be to allow that records and reports designated, including investigations, accounting, or audit reports by or commissioned by a public agency at the state or local level, as well as information and reports from law enforcement agencies would be permitted under information other than hearsay. That is one approach that's offered, and I believe there's some language in your materials about that. There's sample language on page 3. Another approach that was offered by Commissioner Lucas at the last meeting would enhance the referrals process. The referrals process is not subject to the personal knowledge or information other than hearsay component. The draft language, again on page 3 of your memo and your materials, adds state inspectors general, state agency heads, government bodies of political subdivisions where the named respondent is a current or former public officer or employee, to the list of entities or individuals who can currently make referrals to the commission for complaints. And so I'll open that up for your discussion and debate.
Commissioner Bailey? Any comments? Go ahead.
The recommendation or the drafted recommendation allowing the records to be reviewed, is that following our concern about the hearsay language?
Through the chair, yes. These two suggestions under personal knowledge or information other than hearsay, those are possibilities for you to consider as a way to further implement the law in such a way where we would have a little more grace in the things we could rely upon just to initiate the investigation upon receipt of a complaint or referral.
Yes, Commissioner.
I think at our last commission meeting, I expressed my concerns with expanding beyond the personal knowledge and other than hearsay. I think the legislature gave us the guidance in 2024 of where they would like this, where the pulse is right now of limiting it to the personal knowledge and the hearsay exceptions. Because of even within public records, statements can be made, that may not have the same force that we have with personal knowledge, and the significance with which we act when we act in this commission. I think that we need to give this time and allow the changes that the legislature put in place in 2024 to play out before making any further changes to the standard.
Any other comments?
Mr. Chair,
Yeah,
I
go
would
ahead.
concur.
Okay, thank you.
I'm not exactly concurring, but because I think that this has been a troublesome declaration that was done in a very hurried fashion. On the last day of session, this amendment was put on a bill that I supported, and without any discussion, it was pushed through, and it was then given to the Ethics Board to try to determine what hearsay was and what it wasn't. And, you know, it has caused quite a bit of problems, and it's almost been a year since this language was added. I think that we need to go to Senator Gates and have a discussion with him about this before we make a decision, because he may have some suggestions that would be more acceptable to the Senate and the House. And so I don't want us to delay discussion or even any kind of movement about adjusting the hearsay right now, because I think we have found and can be determined many, many instances where they've had to throw out cases because of hearsay that never were thrown out before.
In that regard, do we have y'all been keeping track of statistics of how many are being thrown out because of this change?
Through the chair, we did do some research on that. Most cases that come before us have more than one allegation, as you well know. So when we do the sufficiencies, when we draft those up, it addresses each allegation to determine whether or not we can proceed with an investigation. And one of the factors that we look at is whether or not it meets that personal knowledge or information other than hearsay. So we reviewed cases in 2024 and 2025, and we found some instances where complaints failed due to the personal knowledge requirement. Although many of the ones who did not meet the personal knowledge and information other than hearsay requirement also failed to sufficiently allege a possible violation of the code. So they would have been dismissed under the prior construction of the law without the personal knowledge or information other than hearsay. So it was a handful of them. That's not to say that you haven't been impacted. You have had discussions about the complexity of that type of determination. We've had situations, of course, where a complainant has attached a police report, an audit report, or an outside investigation, where we don't have an exception to the hearsay rule that might apply based on issues of double hearsay or triple hearsay. And so that's where the initial recommendation with regard to being able to accept those types of documents came from.
And just on that point, I'm somewhere in the middle between the two commissioners, because I understand allowing this some time to, I guess, develop and unfold, but at the same time, the amendment here talks about, and again, information within reports by law enforcement officers that, dealing with those on a daily basis, they contain more hearsay than almost anything else, versus, let's say, and not to poke fun at it, just versus information within an investigative report, which I think is a different level, different higher. Investigation versus a police report, I can call a police officer to my house, say anything I want to, they'll memorialize it, and that has its own life. So, but I think I like the recommendation of getting together with Getz, correct? And Senator Getz, sorry, and getting some direction as far as that, on that. But other than that, allowing this thing to play out would be a better idea with that respect. How does this work, Carrie, as far as?
Well, if that's all the conversation that, and discussion on the information and personal knowledge part, we'll move to the next, and then at the end, we can you can give me the direction that you wish.
Can I ask a logistical question?
Sure.
Would Ms. Stillman be the one having that conversation?
Through the chair, the question
Yes.
was whether I would be
No,
having that
I heard
conversation.
her. I don't hear well, but I heard her.
I'm way down here, so.
What, due to sunshine law considerations, what we can't do is have sort of all of you schedule a meeting to go down to the Senate to talk to Senator Gates. Certainly, I can speak to Senator Gates. Certainly, you all individually could speak to Senator Gates. You can't speak to each other about those conversations. We could seek to set a meeting with the Senator Gates's staff or the staff of the Senate Ethics and Elections Committee with a member along with Steve and I. We can work it a lot of ways. I can certainly reach out to Senator Gates's staff and to committee staff to see how we might best facilitate maybe an ongoing conversation about this that would comply with all of the requirements that we have.
And the reason that I ask is, and I know we have a different composition now with former, legislators. You guys are really well positioned to do this, but in the past, I've had to go over and talk to the legislature on behalf of the commission, and I concur with Commissioner Phillips, and because I'm local, so I concur with Commissioner Phillips, and so I'm not the right person to have those conversations, even though I have the bias of being local. Misfortune of being local.
If I might add through the chair, we were invited last year by Senator Gates to speak to the Senate Ethics and Elections Committee about the implementation of the bill. So I spoke, and Vice Chair Deskovich also appeared and spoke, as well as Steve, and we did provide them with an update. They are interested in how that implementation is going, and he has asked for us to continue to have conversations with them and keep them up to date as to how it's going. So they are engaged.
Just from a senator who was there at the time, Senator Burgess made the motion at the last minute on the floor. And I don't think Gates was part of that. So because Senator Gates was actually on this board and had to deal with many, many things, I think he would be more familiar with the impacts of hearsay than maybe anyone else. So that's why I suggested that we go to him, because he may have, you made some great suggestions, but he may have others that he thinks would be good as a starting point, because you're not going to just get everything you want. You know that never happens. So you can get a couple of tidbits maybe from him that might pass, and I think we need to take baby steps toward this anyway. So I think that's why I think that we need to have more conversations with Senator Gates, because I think he'd be very helpful in a direction that this board may want to go in. So that's my comment, because I was on the scene.
Yes, go ahead, Commissioner.
One last comment. You had mentioned the internal affairs investigations. In my private practice, I've had to do internal affairs investigations for clients. And similar to, as you were mentioning, your law enforcement background, people will say things that, when you start digging into them, aren't necessarily the full story. So
Shocking.
So that's my other concern with some of the internal affairs of, as someone who's conducted them for clients, you conduct them, you do the report, and then sometimes things shake out later once you're able to put it through the personal knowledge test and having to do certain things under oath.
Oh, I agree, which is why there's a part of me that agrees with it, rather let it, mature and take its course, but I don't think a conversation with Senator Gates is gonna hurt anything, or maybe just enlighten us a little bit more on that. As far as the point person, obviously Commissioner Lucas can't go, but even though she's local.
I'm busy.
I think you were voted last time to go, right, wasn't it?
It may have been, I think it was 2 years ago. It's just, that trauma sticks.
All right, so what's our next move then, Carrie?
Well, I can continue on with our discussion of these legislative recommendations. I'm happy to reach out to Senate Ethics and Elections and Senator Gates. The sense that I'm getting from you all, even though we haven't fully described what you're moving forward with next year, is that this particular item is not something that you wish to move forward on. Now, the sentiment seems to be that you want to continue to see how the impacts work
Plays out.
while having conversations with Senator Gates and others as to how, I guess, as to his insights
Correct. I mean, I think that's the consensus of the board. Keep it as is, and then maybe try to find out what, I think the commissioner was a scalpel, somebody used here, more of a scalpel approach versus a big blunt, no hearsay at all, something like that. So, yeah, I agree with that position.
It certainly is a law that is in its infancy in terms of implementation. And so your directive is understood in that regard. So moving on to the next item on the list relates to financial disclosure. And this would be recommending that there be a one-time fine waiver, a first-time fine waiver, if you will. This is something that we've had in place for executive branch lobbyists, lobbying firms now who file compensation reports, and it's worked very well. You could recommend that a similar provision be enacted for reporting individuals who receive an automatic fine for a late filed Form 1 or Form 6. They could receive an automatic first-time fine waiver and just have it one time, provided that they did file their disclosure prior to accruing that maximum fine. This type of recommendation would support the Commission's goal of compliance while also providing better efficiency and maybe a little bit of grace regarding fines and appeals, where if someone makes the mistake once and they get that waiver, they may never file a late report again. Or perhaps they've always filed timely, for 10 years, and something happens 1 year and they file late. That instead of appealing, they could choose to institute that fine waiver. That would not affect the things that happen when there's a $1,500 fine, such as the self-initiated investigations to determine if that failure to file was willful. Are there any questions or discussions?
I'm pretty new up here. I'm trying, just, how many of those, I think at least one of them that we've seen in the last two meetings, the person who was being fined indicated that, like, they weren't even aware of it till it made it to the, like, the subpoena phase or whatever, till it got involved in. Yeah, till it made it to collections. I mean, they would still have the room to come to us, of course, I think, and I'm just wondering how many cases fall into, probably a large majority of them fall into that, we're able to get a hold of them, and I know the staff's been doing amazing. I don't want to steal your thunder. So. I would think we get a hold of them before it reaches that maximum in most of the cases, and that's what we're trying to count. And again, so Sikowski, our primary job is trying to get them to comply, right? Like, it's
that
not
is the goal.
Yeah, like get that information out there.
What we tell people is, we'd rather provide you with an opinion from the commission than investigate you. We would rather you file your form than have to fine you, to have to deal with appeals. It serves the purpose of the law. It provides that transparency. That's the goal. It's not to turn us into the Financial Disclosure Appeal Commission.
And most of them, you would think, we hear an appeal long before they get to I know some of them, it doesn't happen until we go into collections.
Through the chair, we get people's attention at various times. Sometimes it takes somebody appearing on a collections list before they realize that all of those notices were serious. Or maybe that's the first time that something has actually reached them. The great thing about the first-time fine waiver, it's like when you're pulled over by the police for maybe being a little bit lead-footed on I-10, where nothing is around, and they're kind enough to let you off with a warning instead of writing you a ticket because you've got a clean driving record. This is sort of that. The first time you get pulled over, here you go, sin no more, and hopefully you've learned your lesson to set cruise control. You put that reminder, you take the commission's call, you believe us when we send you numerous emails and letters and postcards and phone calls where we say you need to file this form. So, I think having a mechanism like this in the law when we've already had it in another area of law where it's proven to be effective, might be an easy, clean thing to do if you all were so inclined. if there's not anything else, I'll move on to the last sort of substantive item, and it really doesn't relate to the ethics code. It was the discussion last time concerning whether or not you all wish to seek a public records exemption for you and or your staff, so that information such as your home address, maybe your home phone if you have a landline, or your cell phone, where certain information could be exempt from public disclosure. This wouldn't absolve you from, you still are filing Form 6, which is a recent change. And I think most of the other individuals who file a Form 6 do now have some sort of public records exemption available to them, because last year the legislature passed a bill that afforded constitutional officers and I think municipal elected officials with the ability to request a confidentiality exemption. People who work in HR, people who work child abuse investigations, of course, law enforcement, firefighters, military, some of you might already qualify for public records exemptions, but not everyone. And now that you file a Form 6, it's possible that your home address would have to be printed there. The nature of the work that you do, the political environment, investigations of public officials, is different now, and the way people feel about that and the reactions to the decisions that are made. The constitutional charge of this agency is issuing public reports on these complaints that we receive. That's the highest calling that you have, whether you decline to find probable cause, or you dismiss without investigation, or a violation is found. This is the objective place where we issue those public reports and people can get that information. Sometimes they're not happy with the information. They're not happy with the decision that you make. Your staff takes hundreds, I think I talk about in the thousands of phone calls that we get each month. Many of those phone calls are people calling about potentially filing complaints. We don't get to take complaints against all types of bad behavior that people think their officials engage in. And sometimes they take it rough when we say we're not the venue, for their complaint. We have had investigations where investigators have encountered individuals where there were situations where they were threatened in terms of close proximity with anger with regard to them being there, with regard to what they were investigating. We had a previous executive director who received a threatening email from a person who was about to get out of prison, indicating that he knew where she lived. We do receive a lot of correspondence from inmates as well. And a lot of them don't.
Mr. Chair?
Yes, go ahead.
I want to weigh in on this. So I already have a public records exemption from my Navy service. I suspect you do, Mr. Chair, from your law enforcement service. I find this a very reasonable ask for the commission and the staff. I don't think it hides any information. We still have to file our forms, so there's not a conflict of interest related to that. I don't think we weigh on anything that relies on where we live. I mean, it's almost non-consequential to that. So I fully in support of this one.
But it's interesting you say that, because, yes, the agency can't release that information, but I guarantee you get on the internet, you'll know exactly where I live.
Oh, yeah,
my phone
yeah.
number. It's incredible. But yeah, I can support something like this. Definitely important, so that that information is kept private.
We have, at the commission's urging, a few years ago, increased our security measures at our office to make us, more safe on a daily basis. So, okay, so those are all the substantive matters. Oh,
I'm sorry, go ahead, I apologize.
I have had 3 hands before I could.
I have Commissioner Bain next to me. He's much taller than I am. I don't know why they put it this way. I can't hear anything. Maybe I should raise my chair a little bit.
I think it's a great idea. I have always voted for public records to be held back for people that, certainly could be attacked. Now, with me, probably everybody in Florida has my phone number, so it doesn't really matter. But I do have a great deal of respect that I think that this absolutely should extend into this board because we're appointed and not elected.
And I think it also applies, to the staff as well. I mean,
Oh, yeah,
they're
absolutely.
there every day, and the investigators go out there, and I'm sure
Every day.
when they confront people, they're not very happy to see them to begin with, let alone the result of our decisions or the staff's decisions. So, yeah, I agree.
So I think we're at the point in terms of the substantive items where we want to sort of have you give us your official debate and vote on what recommendations you would like to make to the legislature, and then I can share some of the technical items that we'd like you to know about that we think we'd like to mention to staff of the legislature to see if some technical changes can be made. So to recap, you have the items from last year that relate to the whistleblower provisions where we had bills last year. You also have the item from last year where we did not have a bill, but we can pursue again this year related to adding foster parents and foster children to the definition of relative for purposes of the gift law. Then you also have you've said no to pursuing anything related to personal knowledge or information other than hearsay, aside from having conversations with Senator Gates and continuing to monitor its impact. There is the idea of the one-time fine waiver, the first-time fine waiver for financial disclosure, and the public records exemptions.
Commissioner?
Yeah, I'm fine for all of those, with the exception that I think we need to have the conversation with Senator Gates in the event that he thinks that there should be or could be something that we could move forward that he might want to pursue in legislation, because he's going to have to file bills too, and it's going to be very soon. And he may have some suggestions. So to just say we're just going to wait to just talk to him and not do anything, I think we need to hear what he has to say, because he might very well say that. Let's wait till next year. But I don't know what, without that conversation, I'm unsure as to whether or not we should just take it off the table.
So how does it work? Do we need to vote on this? Because I'm more into the
Yes.
vote. Okay.
Discussion, debate, vote. Tell
All
us
right.
what you'd like, and that's what we're going to do.
All right, so, one motion, many motions? I mean, here we got, so we have something with the financial disclosure. Let me go back to the
You
beginning.
can do them one at a time.
One at a time.
Okay.
So let's go with the personal, that's number one, personal knowledge or information other than hearsay, correct?
The first one on your list, the first two on your list relate to the
Oh, I
things that you
apologize.
pursued last
Sorry, I
year.
just skipped over, I apologize.
The gift, the definition of relative in the gift law, and the whistleblower protections.
All in favor of moving these forward for legislative recommendations, say aye.
Aye.
Any opposition? Okay, so,
Okay. And then the next one related to that personal knowledge or information.
Can I get a
other than
motion on that?
hearsay.
So move.
no, a motion, can I get a motion exactly what are we gonna do with that?
I would like to move that we talk to Senator Gates before we decide to do anything or not do anything.
Second.
So just a conversation, no action on changing the actual, okay, got a second?
Second.
All in favor?
Aye.
A motion on that?
Yeah, we need a motion. All in favor? Just have a
Aye.
discussion, no changes on the statute, but just the discussion with Getz, Senator Getz.
Aye.
Let me get a roll call on this, better yet.
Aye.
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 No.
Yeah.
Yes.
Yes.
Just, Carrie, just read it back to me the way the motion's gonna read, or the action, it's discussion but no change, correct?
Correct. My understanding of the motion was to have a conversation and seek
Okay.
guidance from Senator Gates with regard to personal knowledge and provision of the oversight. But it will not be included on this year's
Okay.
legislative recommendations, according to what you just,
Thank you.
unless I've
I just wanted to be
misunderstood.
clear on that.
Mr. Chair?
Yes?
Question. Yeah, I think, so after we do all these questions, the next thing we look at is, do we want to have someone appointed to have that conversation? So I think it flows into that naturally, too. So.
Right, let's just go.
No, yeah.
So we're on
Said
to,
someone.
how about the
We're
enhanced?
on to financial.
Right, first time, fine
One-time
waiver
fine
for financial disclosures, all in favor?
Aye.
Any opposition?
I'll say nay.
One opposition, motion passes. Public records exemption, all in favor?
Aye.
Any opposition? Okay, that passes, thank you. Now the technical changes.
Okay, so there are a few technical items that we just want to note, so that you're aware of them, and things that we think deserve to be mentioned to staff of the legislature in case these tech changes can get in there. All right, the first one is, related to being able to count an appeal that is received by mail by the postmark date instead of the received date. Given the issues with the U.S. Postal Service, it can take a really long time for somebody to get their appeal to us, sometimes weeks, where if it had been postmarked, it would be timely, but when it's received, it's not. So that would be a recommendation that would be a technical change to the law. Another technical change would be to ask that the law be clarified such that individuals appointed to complete the remainder of a term of office for Form 6 be required to complete the Form 6 at that time. This is how staff currently advises filers. The other recommendation relates to training. And within the training statute in 112.3142, the law specifies that those appointed to fill a vacant position for an independent special district are required to have the 4 hours of ethics training. However, there's no similar specification when it comes to officials appointed to fill a vacant municipal elected official. So we caught that and thought that because it's in one place and not in the other, it would be good to ask if it were put to apply to others required to take the training. Lastly, the law currently indicates that the Form 10 that's filed annually, it's an honorarium form, gift from governmental entities having a public purpose. It's not required to be filed each year, but when you have something that's required to be reported, the law says it gets filed with your Form 1 or your Form 6. That's a bit antiquated now because Form 1s and Form 6s are electronic and Form 10s are not. And so previously, local filers would file the Form 10s with the supervisor of elections. We would ask for a technical change to just specify that that Form 10 be filed with the Commission on Ethics when it needs to be filed. And those represent the technical changes.
We need to move on those as well, correct?
Steve, I don't think we just need to know if there's anything in there that you don't want us to mention for them to pursue. It wouldn't be included in your official recommendations.
Any comments on that? None?
Anything you think is a bad idea. So, with that, I understand that the recommendations are both of last year's items, plus the financial disclosure one-time fine waiver, and the public records exemption, and then marching orders to talk to Senator Gates. And now you get to decide if there is a particular member of the commission who would serve as a point person during legislative session. This would be somebody who I would communicate with, or Steve would communicate with. Steve and I are the official lobbyists, if you will, for the Ethics Commission. but we would be in regular communication with that member about bills that are filed, you know, what the impacts of those bills might be and what the plan might be. You could also authorize this person to speak on your behalf in terms of deciding that the commission might need to support or not support a particular bill. When there is an occasion where I speak before legislative committees, sometimes they do ask me if the commission supports or doesn't support a bill. Unless you have had a meeting where you have taken that up and absolutely said that you support or oppose a bill, when I speak to the members of the legislature, I'm speaking for information only. I want to remind you, when you did your meeting schedule, we did include a penciled-in meeting during legislative session so that we could potentially meet if we needed to, if there were some meaty issues to bring before you to discuss. But this member would be the point person. They might sometimes come to Tallahassee and speak instead of me. Hooray. So if you'd like to appoint a designated legislative liaison, that would be great.
Who's the junior member on staff? I mean, a commissioner? No, it's, sorry. No, any volunteers, which is a crazy question in the scope of military service, as we know. No volunteers, huh?
Well,
2 volunteers?
well, she says you.
That's some quick backpedaling there.
I wouldn't
Bush.
I wouldn't have no problem volunteering, but if she would like to be the designated person, I could be the designated person, either way.
Or you'd be co-designated.
I work with,
Well, this would not preclude individual members, and we would ask for you to. Or you might hear from me, hey, if you know people, we need for you to give them a call. We might need help getting meetings. The only thing is you all can't talk to each other outside of these public meetings with regard to legislation. You can always talk to me, you can always talk to Steve.
Understood.
Always talk to members.
And may I just say, too, I was in the Senate, I think he was in the House, so we're familiar with different people.
right.
Okay, that'll work then.
I think Commissioner-
I'm sorry, apologies.
Mr. Chair, I just want to make sure, for the record, that we have clear that for our legislative recommendations, we're withholding the personal knowledge and it's purely a conversation at this point.
I think the motion
Okay.
said that
Okay.
specifically.
Yes, sir,
Correct?
that's my understanding.
Right.
Yes, sir.
Yeah,
Mr. Chair,
Yes.
the conversation we're having isn't related to just, I think, but just someone who's generally designated to talk to the legislature, is my understanding, about all of the recommendations and anything else that may come up, but not speaking for us on something we haven't ruled.
Well,
The
we're-
parameters are whatever you all would
Right.
decide that those parameters are.
I think that's what the meeting, that's what the vote was here, like, what's the parameters moving forward, talking to the commission. So Senator Getz can have an idea, but unless we authorize it, it's not gonna,
Can I?
okay, go ahead.
Just to answer that question, I mean, I think another aspect of it is it's not just our recommendations, but if the legislature is hearing a bill that affects what we're doing, or what the staff is doing, then that would be something that this person would go give information about how it impacts our work and have fun.
Wouldn't that be fun?
The stuff we haven't even thought of yet.
I'm used to it.
Okay. So are we good?
I don't know what we decided.
Yes.
Am I hearing from the commission, and there hasn't been a vote, but is the consensus that,
Well,
that we have a Senate liaison and we have a House liaison?
I wouldn't limit
or
it to
how
that,
did
just
you-
the liaison in general. Can we get a vote on that? All those in favor for having liaisons speak to, is it Senator, I don't know, I have a hard time with the title, Senator Getz, and propose the other legislative recommendations on behalf of the commission? Can I get a vote on that? All in favor, say aye. All opposed? Hearing no opposition, it passes.
So is it Commissioner Stewart and Commissioner Bush?
Yes. Sorry, I thought it was it then. I apologize.
I just want to make sure.
Sorry.
Try to leave me out, too.
No.
It's okay.
the more engaged our members are, it is meaningful to members of the legislature. So should one of your recommendations be taken up, that I can stand on and say the commission, recommends this, they support this. Getting members to engage on that will be helpful as well. If there are other bills filed, as there often are, that affect the code of ethics, we will keep you informed on that and, speak to you to make sure that we're engaged as necessary and as appropriate with legislation that might be filed.
Okay. So,
We're now to rulemaking.
yeah, we're not, get a motion, if I can get a motion to take a brief break, just a quick break. Second? All right, any opposition? All right, we are on break. Changes of the public hearing or any materials we have received. The commission may also make technical changes which do not affect the substance of the rule. I'll ask Gray, who prepared the draft item, to explain the rule changes and to put us on the proper posture, and then we'll proceed with the public hearing. Deliberation.
Chair.
Thank you.
Commissioners, this particular series of rule amendments all pertain to rules in one rule chapter of the Administrative Code, Chapter 34-8. That's a rule chapter that, among other things, it all pertains to our financial disclosure forms. Among other things it does, it incorporates by reference the different instructions for completing the financial disclosure forms, meaning the instructions are actually considered part of the rule because they're incorporated within them. And these would be instructions for the Form 6, 6X, and 6F, and the instructions for the Form 1, 1F, and 1X. Now, each year, we come back before you and we ask for you to update and then re-adopt those instructions and then reincorporate them into the rule. Usually they pertain to making changes if the legislature has had some law changes regarding additions to the disclosure laws that we need to reflect in the instructions, or sometimes it's just changes that we think need to be made just to increase coherency in the instructions themselves. And that's our goal here this morning. Thankfully, I don't believe we need to overhaul these instructions today. There's just 3 relatively minor changes that you were recommending you make the instructions this morning. One of them was actually proposed by Commissioner Lyle during a meeting last year. These 3 changes are summarized in the memo provided in your meeting materials. I just want to highlight them very briefly for you. First, very simply, we need to update the calendar years in these instructions. The Form 1 and Form 6 instructions need to be updated to reflect the 2025 calendar year, and the Form 6F and 1F need to be updated to reflect the 2026 calendar year. Second, at Commissioner Lyle's suggestion, we want to make just a very slight adjustment to the language in the instructions informing filers how to value real property. This would be in the asset portion of the instructions for the Form 6, 6X, and 6F, and the real property portion of the instructions for the Form 1, 1X, and 1F. This change doesn't alter the substance of what the instructions read. It just adds a little bit more clarity to it. Currently, those instructions say that a filer should value real property at its market value for tax purposes. The only addition we're making at Commissioner Lyle's suggestion is having it read, you value it at its market value for ad valorem tax purposes, just to remove any confusion about what we mean by that. Third and finally, there's a portion on the instructions for the Form 6, 6F, and 6X dealing with household goods and personal effects. Filers who file a Form 6 have to disclose the aggregate value of their household goods and personal effects if that amount is more than $1,000. Now, the financial disclosure statutes actually define what is meant by the phrase household goods and personal effects, but for whatever reason in the past, that definition has not been included in the instructions. We just thought it'd be a good idea just to take the statutory definition verbatim and put it into the instructions, again, to remove any confusion for filers. So those are the 3 changes. Just update the calendar years, indicate you value real property at its market value for ad valorem tax purposes, and include the statutory definition for household goods and personal effects. We have submitted these changes to JAPSI, which is the body that reviews proposed rules to make sure that the agency has authority to engage in the rulemaking. They've had no feedback for us. We've also published these in the Administrative Register, and we've waited the amount of time needed for the public to submit comments. We haven't received any public comments on these changes. So if you approve them today, the only step remaining will be to submit these amended instructions for adoption with the Department of State. So I submit these changes to you now. I'm happy to answer your questions.
Thank you. Is there anybody from the public who'd like to make a comment at this time? Okay, seeing nobody. Any comments here from the commission? Questions? Go ahead,
Mr. Chair?
Commissioner.
I guess two questions. First, are we voting to adopt this?
Yes.
We do it, and then I think recommendations 1 and 3 make a lot of sense. On 2, I wanted some discussion. Commissioner, I'd really be interested in, you're in real estate, in the domain and stuff. Do we think that this is for assessing your real estate value and using the property tax, the elected property tax appraiser's ad valorem number versus what might be considered a fair market value? Is that what I understand correctly?
No, currently the instructions read, you value real property at its market value for tax purposes, which this body approved that particular language last year, which I think means that you look at what the property appraiser feels it could fetch on the open market before you start taking out all of the different adjustments and exemptions, like the homestead exemption that you need to take out before you finally arrive at the value it's going to be taxed at. We're not trying to change substantively what we're saying there. Commissioner Lyle that last year just thought that it would remove any source of confusion and almost underline that you use market value if you just put in market value for ad valorem tax purposes. So this is not intended to be used to change the substance of the instructions at all, just give a little bit more clarity that what we're zeroing on here is market value.
Any further questions? Comments? So can I get a motion to adopt the rule changes?
So moved.
Second? All in favor?
Aye.
Any opposition? Hearing none? Passes. Thank you very much.
Thank you.
You have a comment to make, Commissioner Lucas? So pursuant to the statute, thank God for that. No, I'm just kidding. The term of the commission chair is 1 year. So sadly, it's time for me to pass the gavel to a new chair. As such, the next order of business today would be the selection of a new chair and a vice chair. And I just want to say really quick, I've been, extremely honored. Didn't realize how much work it was. That's why Commissioner Lucas gave it up so quickly like that. And she's over there smirking. The record reflects we have a smirk from Commissioner Lucas. But no, all kidding aside, it's been an honor, and thank you very much for nominating me when you did. And to the staff, I think it was daily phone calls we were making, or weekly phone calls. That's what it felt like. But it's really important. It's a lot of responsibility, and definitely a lot more informed and knowledgeable about what goes on here, and it's not easy. So first, there needs to be a nomination for a chair, and I'd like to open that up with the same precedent that we did before, which is maybe no precedent at all. So I'd like to nominate Commissioner Phillipson.
Second.
That was quick. All right. Got a first and a second. Let's take a vote on that real quick. All those in favor? Aye.
Are there no other nominations?
Well, we'll move on that one first. That's the first. So we have a first and a second on him. So unless there's a vote and it doesn't go by, then we'll move on to another person. But we take a vote on all those in favor?
Well, I think,
Oh, I thought it's single by single.
I was
Sorry.
kind of wondering.
Okay.
because
So then-
that leaves everybody out.
All right, not a problem. So exactly procedurally, how do we go forward with this? Any other
I guess
nominations?
they may be where I am, which is I just don't know what we're voting on. If we're voting just to put that name up, and then you're going to vote to be on who's going to be chair, that's one thing.
Well, it's really for the nomination, correct? Nominate that person. Procedurally, you can have more than one person on a single vote?
No, you can have
Right.
With the roll call, the last time that there was a contested vote, and sometimes there isn't one, right? But the last time that there was a contested vote, the roll call was, instead of yay or nay on a particular person, it was the name of the person that was being chosen. So some people voted for Commissioner Gates, some people voted for Commissioner Lucas, and that was the roll call at the time because there were two people up. You could do it a different way. It's entirely it's your meeting to run.
No, I'd rather run it the way, My recollection was there was one name, and then we voted on it, and then it didn't pass, and then we went on to, or not like that, maybe not like that. All right, so then we'll have another nomination then for another chair. Does anybody else want to nominate anybody else?
Nominate yourself.
Steve, nominate yourself?
I don't see any
No.
reason why not.
No, I'm just wondering,
Yeah.
procedure, that's fine, okay? Would you like to nominate somebody?
Well, I mean, could you nominate yourself?
I see, Steve says yes, you
He said
can.
yes.
All right.
I can't nominate myself.
Mr. Chair?
Yes, go ahead.
Just for clarification on the rule, so the rules for serving on chair, Mr. General Counsel, you could say, I think the current one cannot serve, and there's no restrictions on vice chair. Do I have that right, or can we just go over that?
Yes, through the chair, there is a law that speaks to how you choose your chair. Section 112.321, subsection 2, it's one sentence. It says, "The members of the commission shall elect a chair from their number, who shall serve a one-year term, and may not succeed himself or herself as chair." So your pool of potential nominees are those among you, except Commissioner Fuste, who cannot succeed himself. There are those rules do not apply to the election of a vice chair. It only speaks to the chair.
So we have one person who's been nominated with a second. Is there anybody else who'd like to nominate anybody else? Okay, you want to take a vote on, go ahead, Commissioner.
The one person,
Yes.
who is the one person to nominate?
I didn't,
Who is the
oh,
nominee?
I'm sorry, Commissioner Phillipson,
Okay, well,
all the way on the right.
We have a lot of new folks here.
I'll nominate myself. I nominate myself.
Thank you. I have a motion for Commissioner Bush. Do I have a second? Okay, no second. So anybody else would like to nominate anybody or themselves? All right, so then we'll proceed on with the vote. Okay. All those in favor of Commissioner Phillipson being the new chair, say aye.
Aye.
Any opposition? Okay, hearing none, it passes. Congratulations. Okay, and now, are there any other, any nominations for vice chair?
I nominate Mr. Bush.
Okay, got a first for Mr. Bush. Do I have a second for Commissioner Bush?
Second.
Second, okay. We have a first and a second. Any other nominations? Any other nominations?
I'll nominate Ms. Lucas.
Nay. Nay.
Wait, do I get it? Not yet. You'll get your turn. Do I get a second? Second. Oh, yes.
Well, if you did, discussion?
No. So I have a first for Lucas and a second, notwithstanding her objection, but, okay, so, when you have, okay, so those in, yeah, let's do a roll call. Right, and indicate who you're voting for in the roll call. It's gonna be the best way.
Present?
No. Indicate who you're voting for.
I think you might.
I'm voting present. Oh, Lucas or Bush? Bush.
Yes.
Lucas.
Bush.
Bush.
Lucas.
Bush.
Yes.
Congratulations, Vice Chair.
Okay, congratulations to the new chair and vice chair. Yes, don't thank me later. Okay, reports. Item number 11, chair's reports. I don't have any reports. Executive Director?
Well, as you know, I have reports. I don't have anything to add to my executive director report. We've already handled legislation. So with your permission, I'd like to chat about e-filing ever so briefly. As of September 2nd, which was the grace period deadline, overall compliance was at 97.95%. Form 1 compliance was 97.94%, with Form 6 compliance at 98.11%. We have less than 800 delinquent filers out of more than 36,000, 38,000. There are a lot of filers. This compliance number is about 1%, maybe a little more than 1% higher than what we had last year, so we are trending in the right direction. I think the highest compliance the commission has ever enjoyed was 99%, and I would love to get back there, so we hope to keep building on what I will call 98% compliance this year. People are still filing. They're filing late. They're accruing a $25 a day fine for each day that their filing is late. We did roll out the fine component, fine and appeals component of our electronic filing system, so that means this year's fining period is in real time, which we're very excited about. So if you file your form September 3rd, a day late, you filed your form, you get the success, you filed the form, and then you get an email that says, you filed a day late, your fine is $25, you can appeal or you can pay your fine via this link. That's going great. Some of our compliance outreach efforts this year, the law requires weekly reminders to filers who had not filed as of July 31st. Those, of course, went. We also mailed postcards. That's not required, but it's a very effective means of reaching people who maybe aren't checking their email like they should and like the law requires. And with e-filing in its infancy, we wanted to keep doing that. We also do phone call reminders. Commission staff, especially Lynn and Keith, I want to recognize for that. They called all the Form 6 filers who had not yet filed, called them in advance of the grace period deadline with a friendly, gentle reminder to get the form in. Our call center placed reminder calls to every Form 1 filer for whom we had a phone number. They made a total of 6,462 outgoing calls, which represents multiple calls and efforts to speak to the person directly, because their statistics bore out that 55% of the filers who they spoke with directly stopped what they're doing and filled out the form while they were on the phone with our call center representative. So that was good to know. Those are metrics we didn't have last year. We closed the call center on August 29th at the close of business. They handled over 5,000 incoming calls, over 8,000 outgoing calls in their efforts to assist filers. Fewer than 5% of calls had to be escalated to staff. That's a decrease from last year. So people are getting the hang of it. Perhaps our call center reps were doing an excellent job as well. The feedback on them was good. This is about 3.5 years worth of Form 6 filers doing so electronically. We've noticed a decline in calls for Form 6 filing assistance, which has been great. We don't have specific metrics on that because that's handled in-house, and we don't have enough fingers and toes to count that. We would expect, if the court upholds the law requiring municipal elected officials to file a Form 6, that those phone calls those numbers might go back up, but it's nothing that we can't handle at the staff level. In the coming weeks, staff will meet to sort of do a debrief on this filing season and discuss our metrics, what worked, what didn't, and what we need to look at for next year. And we will be coming to you soon with regard to a recommendation on next year's practices in terms of a call center. And if there are not any questions, that will conclude my remarks on financial disclosure.
That's going to be it?
That's it for me.
Okay. Does anybody have any questions or comments to make? Let's come to that time. Get a motion to adjourn the public session? Second? See, that I handled better than the voting, huh? Yeah, session is adjourned, the public session is adjourned. We'll be back in 15 minutes.